and the state declared emergency. This meeting will be conducted exclusively through teleconference and Zoom video conference. The COVID-19 state of emergency continues to directly impact the ability of the members to meet safely in person and presents imminent risk to the health of the attendees. And the state declared emergency. This meeting will be conducted exclusively through teleconference and Zoom video conference. The COVID-19 state of emergency continues to directly impact the ability of the members to meet safely. I get to hear myself.
Sorry, yeah, that always happens. I have to start the live stream and then I have to close out of YouTube.
I have to work on my elocution more, I think.
Oh, that sounded really good, Mike.
Did?
12 times.
Very official.
Therefore, no physical meeting location will be available. To access the meeting remotely, join from a PC, Mac, iPad, iPhone, or Android device using this URL, which is on the city's site. You can go there and find it. If you do not wish for your name to appear on the screen, use the drop-down menu and click on rename to rename yourself to be anonymous. To request to speak, use the raise hand icon on the screen. To join by phone, the number is, and it's on the PAB website, 1-669-900-6833, and enter the meeting ID, which is also there as well on the PAB website. If you wish to comment during the public comment portion of the agenda, press *9 and wait to be recognized. Thanks. So, Director Lee, shall we call to take the roll call?
Sure. Board Member Calavita.
Here.
Board Member Chang and Chair of the subcommittee and the board now.
Yep, the chair.
Board Member Leftwich.
Here.
Board Member Owens.
Here.
And Public Committee Member Saginar.
Here.
Okay, we have quorum.
Great. Okay, so is there any member of the public? Well, actually, we have the approval of agenda. My apologies. The agenda is fairly straightforward. Are there any questions about the agenda?
I move to approve.
Okay, someone will second?
Yes, I'll say.
Great. So should we?
Oh, you should not. You can approve by ask if there are any objections.
Are there any objections?
Okay.
Any objections in the motion? No. And can we then approve by
General consent? Yes.
general consent? Seeing nor hearing any objections, we have approved by general consent. Okay, so are there members of the public who would like to comment?
I see one member of the public. You may raise your hand if you wish to comment.
So it appears that the member of the public is not interested in commenting. So do we have an approval of the minutes?
No, we don't keep minutes. We can go
straight to
right into business.
Jump right into it. Okay. All righty. So shall we pull up, as we did previously, the
Yes.
latest version, which many of us have worked on and add comments on. Thank you for those folks who did that. Much appreciated.
Okay, can everybody see that?
Yes, it looks good.
Okay.
So is Purple Kitty and then, I'm sorry, Board Member Calavita. And
I don't think mine got in, did they, Kathy?
No, they didn't. Well, there might be some earlier comments of yours, but not the more recent ones.
Okay.
Do we want to, I know the very recent ones just from, was it today or yesterday?
There were some from today from Kitty, and then others from Kit, earlier comments from Kit and Julie.
I sent in last week, but can you make that screen bigger?
Sure.
Do we, and thank you, Director Lee, for putting this together. I know it's a lot of work, but do we want to somehow, yeah, that's good. Do you want to somehow pull up Board Member Calavita's and Ms. Saginor's comments?
Well, I've incorporated Ms. Saginor's comments, and there are none of Ms. Calavita's of Board Member Calavita's in this section.
Okay.
So we don't have to worry about them yet.
Are we going to start at the beginning?
At the last meeting, the agreement was to start at this section, section 3. You just finished the biggest section by far.
That's right. So we don't want to go back to the
You
beginning.
wanted to get through the whole thing at least once and then go
Yep.
back to the beginning, which I think makes sense because you could theoretically keep going back to the beginning and never finish.
Right. We don't want to do that. So I think that makes sense. If there's no other, if there's a disagreement or objection to that or other suggestion, we would continue from 3 here, go all the way through as quickly as possible since we've already had some revisions and basically say yay or nay on the revisions. And then start from the head to tail again. And we're hoping that we can do this over the next 2 hours today and 2 hours the following meeting. So we're trying to keep ourselves to 2 hours to keep everybody from burning out. It's now 6:53, so 6:45 to 8:45 would be the marker. So shall we just proceed then with 3?
Let's go.
Okay, let's go. And board member Owens had her hand up. Do you still have a question?
No, I was gonna say that I didn't see any of section 3 on Kitty, so.
Okay.
just-
Cool.
I didn't have anything on section
She
3.
didn't have anything on 3, yes.
Okay. Katie, is it too much? Is it difficult for you if when it comes up in the different sections, you could say when we get to like B1 that I had a comment?
Yeah, when we start at the beginning again, I have a few minor things at the beginning. So let's just go through starting here.
Okay, we're gonna start at board member Leftwich has her hand up.
Yeah, I guess under B3, and I guess this is right out of the charter amendment. I'm a little confused why, so it says within 15 days of receiving an objection, blah, blah, blah. The director in their discretion may notify the complainant that either the, then there's the A and B. And I guess it just seems weird to me that there's discretion there.
Okay, so
But
is
is
that,
that,
thank you for bringing that up. Is that the first thing in the order? Is there something above that though? I want to just double check. The stuff in green was from before, right? So we don't have anything until we get to 3. Is that right? Well, there's the internal affairs. That's purple.
Yeah, quite
That's
frankly, I don't have a marker for whose change that is, but I think so it doesn't really matter.
Can I, just before we get into the weeds, can I just ask a general question? What are the crossouts about? And sorry, Kathy, I didn't notice this until now. I see
These
there-
are throughout the original document throughout made references to the charter or the old PRC regs. As we've been going through and discussing the various sections, I've been taking them out. They're for reference only.
Okay.
Oh, that's the old PRC. I thought it was a new measure. Okay.
Okay,
No,
cool.
this section.
Is the charter amendment.
Yeah, these are references to the charter amendment and
Where
this.
it says article
Yeah, Article 18,
and the reason, but there's a strikeout line in it. What's the reason for that?
because it's going to be eliminated. That's why.
Okay.
It's not intended to.
I get it. It's just there for us. Okay.
It's for reference.
Okay, yeah, the charter amendment will
It
eventually.
looks like a deletion, but I get it. Okay.
Well, it is.
No, I get it. Moving right along.
Yeah, I was gonna say the two of you have been working together for a long time, huh?
Yes.
Yeah, kind of like an old married couple,
Board member Owens and Montgomery and Leftwich have questions. I think first, board member Leftwich, you want to finish your thought from?
yeah, and maybe, I guess I always struggle a little bit with stuff that's in the charter because it seems like sometimes we can supplement and change it a little bit and other times we can't change it. And so I guess I'm just surprised that it's discretionary, what the director does there.
Okay, so in that 1 minute, let's put a flag in that. Let's focus on discretion when we come back and we'll double check board member Owens and Lieutenant Montgomery. I can't remember who raised their hand.
Go to Lieutenant Montgomery first since his hand was up first.
Okay, yeah, Lieutenant Montgomery.
Yeah, just before we got too deep into it, I wanted to circle back to the internal affairs in section 2. The internal affairs, think of them like the investigator, like the PAB or DPA's investigator. They don't make findings, neither does the internal affairs. The findings are made by the chief.
The
Okay.
So
chief.
it wouldn't
Okay.
be an internal affairs finding.
Thank you.
Oh,
Let's flag
So-
that right now, just so we have it.
So Lieutenant, shall we say if the internal affairs recommendation is not sustained?
No, they actually don't even make recommendations. It goes to a board of review and the board of review makes a recommendation. The chief makes the finding. So I think
So
it's actually better neutral as if a finding is sustained,
If the finding is.
then it's not possessive.
Don't refer to internal affairs, you're saying, just say.
Oh, I see. So it was better the way it was. If a finding is
Right.
okay.
Just leave it at that. What do you guys think? I think that makes sense.
Yeah,
Okay.
Okay, and then board member Owens.
So I have a question. Since this is almost directly out of the charter, why don't we just use the charter language and leave it at that? Because we can't modify that language anyway. So let's just use, this is almost directly from the charter. So why don't we just use the charter language in the story?
Yeah, okay. It just seemed weird to me that it's discretionary, but that was what I was saying. If it's in the charter, I guess it's in the charter, but sometimes we can, add to stuff that's in the charter, but I guess, you know what I mean? There is a little bit of wiggle room because the charter is a little more bare bones, but in any event, no need to spend time on it.
Kathy, is there anything different? Is there anything
This
here
is,
that,
this is pretty much what the charter says.
okay, so let's go with it.
Okay, let's go with it then. Can you scroll up a bit and try to make sure, am I looking at the right? Yeah. Okay. All right. So any other questions? Lieutenant Montgomery and board member Left, your hands are still up. Okay. So we're going to roll down.
Okay, so here, you might want to take a closer look, section 4.
Okay.
So this is my note here. New details are not in the charter and there's no counterpart in the PRC procedures. So
What's that a reference to though, Kathy? I wasn't, so it's a reference to what's above? or below?
yes,
What's above?
all of section 4 is
Okay.
my attempt to put a process to something that the charter does not really delve into.
Okay.
Yeah.
I think this section looks great.
The charter does talk about that B part of 4. That's pretty much right out of the charter too, because it talks about if there's objection, if the complainant objections. I'll just tell you where it is in the charter because I saw it in the charter. Where is it at?
Okay. So we're going to. Let's specify what section we're looking at for which part?
4B.
4B. Review panel shall evaluate the investigative record to determine.
Yes, that's true.
Okay. Okay, so it's okay.
I'd say whatever, for me, whatever's in the charter, that's what it should say. Because I mean, that's directly out of the charter, pretty
Right.
much, right, Kathy?
Yes, that is.
What section of the charter is that in? I have a physical copy of the charter in front of me.
19
Number 19.
E1.
Yeah.
In E1. It's just cross-reference the language.
Oh, and then F also.
So I'm gonna should I read out the 19E1?
I don't think.
You'll
No, I don't think we need
No.
to.
We don't need to.
Okay, it looks right? I don't see, it looks very similar, if not exactly the same.
Why don't we just make it all exactly the same and then we don't have to worry about, is it right?
I don't see where the review,
Other than the part that Kathy added in, that's more detail on what the review panel is supposed to do. I think
Okay.
that's the only thing that we should be talking about because the rest of it is the charter.
so 4B is not in the charter, right? There's nothing about the review.
B is in the charter. 4B is in the charter.
I don't see it.
It doesn't say that the
19, yeah.
panel, the review panel aspect of it is not in the charter. But
Yeah. I don't see-
what the review panel does is in the charter.
Right, but I don't see 4B.
So 19F, the last sentence is, it doesn't refer to the review panel. It refers to,
Chief of Police.
It refers to the board. Within
the
45
board.
days, blah, blah, blah. The
Yeah.
board may, 1, dismiss the objection, 2, issue a report agreeing with the chief, or 3, issue a report disagreeing with the chief. If, and then certain things, and this is reflected, this
But
is
that's number 5.
right.
Yeah. So 4B is just your clarification of the details of what the review panel will be doing.
Right.
Right.
And that's not specified in the charter.
So it doesn't, just want to make sure, it doesn't seem to be incongruent with the charter by using the
No.
language review panel. It's just
No.
like an explication.
And it's straightforward. It investigates the record and so forth.
Right. That part of it is in, like, if you look at 19E1I,
Notify the complainant that the objection has been accepted and that the Police Accountability Board will convene to conduct a review based upon the investigative record provided by the department, or, yeah, 2.
Mhm.
Okay.
I think it's fine. Oh,
I think
guess
it's
we-
fine.
Are you okay with that, Board Member Owens? The review panel is just our terminology for some clarification.
yes.
yeah, it's a I would call it a refinement of the process because it talks about the board. And just as for hearings, we don't have the whole board doing a hearing.
Yeah, no, that's fine.
Okay.
Okay. Now, Lieutenant Montgomery has his hand raised.
So that would be my question is, it sounds like the charter imagines the whole board and a review panel imagines a subset of the board. And if you're saying like 3 people will come together instead of the whole board, it doesn't seem that that's what the charter's saying.
Okay, let's double check that.
Well, the charter does say the board. I would think that the board could delegate to a subset this responsibility.
So that's what my understanding was. Lieutenant Montgomery, do you have like a procedural or substantive concern about that? Is that what you're trying to say?
Well, usually when something is a serious nature, such as an appeal, it usually goes to the entire, like, for example, if you made an example of court, you go to the entire panel of judges instead of a subset in the Ninth Circuit. It seems like the
Actually,
seriousness
first you
elevated
go
more.
in the Ninth Circuit, first you go to a panel and then you go en banc.
Yeah, so I guess to me, it seems like a serious thing, so an appeal of the finding, but I'm just throwing it out there because I imagined it as the whole board when I read it. think-
Kathy, 3A, where it talks about the board will convene a review panel. Did you get that from the charter amendment?
No. 4A, is that what you said?
3A,
3A.
the
Oh,
objection
the board,
is
right.
accepted.
This
The
is,
board will convene a review panel. Is that in the charter?
no, I made that up.
Um,
I'm suggesting it.
So let me ask a question of the lieutenant. Do you think that it's not, I'll use the term fair, to have a subset? Or do you think it requires more thought from the entire board to make a decision because it is, I just want your thoughts.
Yeah, so I think there's been several instances where we haven't been strict to the charter's language. And the charter's language was negotiated over carefully. And every time that we diverge, I think we open up another string of conversations of things already negotiated upon and have to renegotiate them. To me, it seems serious to overturn the finding of the chief. And so if it says board, I would expect it meant the whole board. I understand that for logistical reasons, the desire to do a smaller group or say it's similar to a regular panel. But I think there's several times where we just kind of get away from what the charter says, and I know that those things were carefully negotiated. And so in a way, they put us ahead in the negotiations process when we don't have to diverge from them.
I personally am comfortable with the board doing it because it is overturning the chief. I'm personally comfortable with that. I mean, I don't know how my peers feel, but I agree with what's in the charter. So, and it is overturning the chief, which is a very serious thing. So I'm comfortable with using the charter language.
I'm fine with that too. I just think it's
with-
not absolutely clear that we have to, that the charter is the only thing out there, because the whole point of having regulations is to flesh things out and to provide some rules. So I'm fine with it here, but I still think it's not like it's written in stone just because it's in the charter, depending on what it is. But I'm fine with saying the board here.
Okay.
I am too. So how would we phrase that, Kathy?
The board will convene and this will be struck.
The board will convene to conduct a review.
Yeah,
Okay. And then later on where it talks about hearing panel, but it's also in the definitions. So if we're not having hearing panels, it should be struck from the definitions.
this is a
We
review
do.
panel.
Or review panel, I mean.
Is
If
it
this
in the-
review panel is only for the IA.
Contesting the
you're
chief
right.
decision.
So
You're
if we're
right.
not,
So
if we're
we
not
should
gonna
get
have
rid of
a,
it.
it needs
It's
to-
number, the
Right, the
18,
definition.
the definition 18, we should get rid of.
Okay.
Okay. So it does, but that doesn't constrain the board. If we use as is described in the charter, the language of the charter, I don't think that presumes that it restrains the board from creating a review panel.
I don't know, that's,
Understanding?
You mean for
that's
the,
the question.
I
For
think
over-
it does. I think it does restrain the board.
I mean, everybody has to be on it then, all of us?
just for this particular kind of review, not
Correct.
for the regular complaints.
Okay.
So is it different than, and I guess I'm asking Lieutenant Montgomery what his thoughts are. Do you feel that the board convening 3-member hearing panels for DPA filed complaints, do you think that process works in your opinion?
Well, I guess what strikes me as different is that this is after the chief has already made a finding. The regular one is before the chief makes a finding. It's advising the chief. So I see that as a little bit different. Not to obviously, say anything about the efforts or the quality of the decision coming out of a 3-member panel. It's just about the fact that it's before and after. It's more important to me.
Yeah,
Yeah, I'm okay with this change. I just want to make sure we understand that. Therefore, it apparently means the entire board, and
that's fine. It may not even happen that often. I don't,
okay. Investigator Norris, do you have another question?
No, thank you. I'll lower my hand.
Thanks.
Okay, so I'm going through to change all these references.
I will add, we will need to keep in mind that I guess all of this has to happen within 45 days. We have to convene the board and we have to issue reports and all of that. So again, the director was trying to come up with a similar process as is the hearing process to streamline this for the board. But it's just something to think about. The timing of that, getting you all together and getting the reports out and responses and whatnot. But like I said, it's something to think about.
Well, so we have 45 days. We meet every couple of weeks. And at one of our meeting, we couldn't do this in closed session.
We should be, but all I'm saying is it's just something we have to think about. Timing, notice to parties and all of that. I'm hoping that it won't be a problem, but
no, I don't see, we'll need a quorum, but that's, I think it's fine.
okay.
I think while you're in this section, I would
Yes.
get rid of the or after A. Just because you don't need that or.
I'm sorry,
I'm
where?
pointing at my screen, 5A.
5A.
You don't need the word or there because you've got this, that, or.
Right. Okay.
Are we done with this section?
Okay.
I think so. Anything else in this section?
No,
Okay, cool. Let's continue forward. Unless anyone else raises a concern.
so I have changes in Roman numeral 4.
So
Okay.
I've reflected these are the ones I put in, Kitty, between
Was it-
Well, no,
just now.
well, I don't see that. No, I'm suggesting eliminating and or anonymous.
Right, and I struck them out. It's hard to see. It's hard to
Get rid of
see
the-
here. I think it's a little easier to see here.
I can't see, but anyway, let me just read through what I would change in this section. I would call this,
Let me give you a very quick tech. If you have are you on your iPad or are you on a computer?
iPad.
Okay, it may make a difference. I don't think so, but if you go up to your screen, you know how it says you are viewing Catherine Lee's screen. To the side, there should be in the color black. It says View Options, and you can pull that down, and you can increase it.
I'm fine doing it this way. I'll just,
Okay, but you can increase the size of the lettering is what I'm saying.
oh,
From
okay,
that tab up there to 100%, 50%, 150, 200.
Yeah.
300.
right. Okay,
Okay.
so on this section, I would strike and or anonymous. And
Okay.
just call this informal complaints. As
Okay.
it
That's what
was,
I thought we did that last time around, so I was kind of surprised to see it. But now that I see it struck on the
It's-
screen.
Yeah,
I
I can
don't
see
know.
that it's struck. All that's,
Well,
all the
I
anonymous
struck
stuff
it.
is struck.
I struck it just now. This doesn't appear, this is not the version that I sent you.
yeah. Okay, moving forward.
Yeah.
An informal complaint is a communication and strike and or. In other words, strike and or anonymous in all of these places where it used to appear as unnecessary. I'm not suggesting that some complaints might be kept confidential, because if you see under 4A, it says such complaints may be anonymous if requested by the complainant. And so I'm suggesting striking and or anonymous throughout here as unnecessarily repetitious. That's
Okay.
all.
I really thought we had done this a while back.
No,
'Cause I
we
remember,
hadn't.
oh,
We-
okay, I
we
remember
hadn't.
discussing it.
We hadn't, but we talked about the anonymous complaints, but I had not suggested deleting all of this erroneous, extraneous language.
So it looks like board member or Director Lee has done so. It looks like they're all struck, if I'm not incorrect. So
It
the
should
next-
be unless I missed anything.
looks like all of
But
that. Do you see anything else lingering there?
There's in D, there's one.
In D, there's one as well.
Okay, so we're gonna
You have to
scroll
scroll
down.
down.
And board member Owens raised her hand.
So I'm gonna let you deal with D and then I want to go back up to A.
Okay, so let's take care of D and let's go, we deleted that. Let's go back up. to A.
D's done.
D anonymous is gone. So what's on A here? Board member Owens.
So on A where it says that this informal complaint that identifies an officer or officers by name, badge number, or other identifying features. I don't know about the other identifying features. I mean, it just seems kind of,
It seems vague to you. Is that in the charter?
No,
no, this is not.
I
in
don't know where that came from. That's not my language. I'd be happy with saying name or badge number.
Well, what if they don't know who the officer is?
They might not know.
I mean, I think that's why that's
Okay,
there.
so if you describe somebody, right? And how, I mean. I
What
would
if-
say
what if
this,
they say-
for a lot of people, officers look the same in their uniform.
Yeah, that's
You know what
true.
I mean? And to identify an officer by just saying, it was a guy, he was this tall, he had this kind of hair. I mean, I personally think it may be difficult. Now, it's possible that you know, they could identify somebody because there's something that's unique about a particular officer.
Oh,
But
okay.
I think that would be a little nebulous.
Well,
Chair,
but I guess I'm thinking, what
Oh.
if I saw something and it happened in front of Starbucks and the cop was on his bicycle? I don't know his name or badge number, but I saw him assaulting somebody. So if I come in and I want to file this complaint, it's more like I mean, presumably somebody could figure out what officer was there on a bike, you know, at that time of day, right?
okay, can I jump? I know there are a lot of raised hands and I really need to jump in to sort of refocus.
Okay.
The informal complaint is when somebody writes us a letter and says, I saw officer so-and-so, or the officer with badge number so-and-so was twisting somebody's arm and almost broke it when they're trying to arrest somebody. We cannot treat that in the public. So what this is saying is to file, we don't want to encourage people to file informal complaints. If people want to complain, we want them to file on a complaint form, and then we know what to do with it. There's a whole process. Often people communicate with our office and say, they'll email. I saw officer XYZ and name the officer, do something, and it was bad. They're not filing a complaint on our form, so they're not starting that process. We have to have some, and Kitty, I don't know if you were on the PRC at this time, but the city attorney, one of the deputy city attorneys, worked with us to figure out how, and wrote an opinion about what informal complaints are and the various ways that the commission could develop to handle these. So we're not saying to people, you have to identify an officer. What this is when we get a communication and it does identify an officer, it cannot be handled in public. We have to handle it confidentially. And this is what this system is, this process is intended to address.
So Kathy, it's always anonymous? What do you mean you can't handle it in public?
You cannot make public a complaint against an identifiable officer.
What if the,
And
what if it's,
I'm not
what if it's-
Talking
what if
about
it's an-
making it public.
Kathy, what if it's an informal complaint from a member of the public and they don't name the officer? Is it still
Then that could be public.
like
Like this
okay.
whole situation with
All
the inebriated guy. We don't know anybody's name, but it's all over. Well, I guess that's a little different because that's already been made public by the press and we had nothing to do with it. But if somebody came to us and said, hey, there was a situation where the police, let's say nobody knew about it. It wasn't public, somehow it wasn't made public and they came to us. That could be discussed in public. But
it seems like it shouldn't be.
well,
But Kathy, I don't understand your focus on discussing in public or
Right.
not. I meant
I don't
to write
even-
this, most of this section comes directly from the PRC regs on informal complaints. And so what it is somebody from the public comes and gives us some information, which if it seems warranted, would then become, according to how I've written it here, would then become a board initiated investigation or complaint.
yeah, so you kind of changed the focus of what's going on here. So now I understand what you were doing because I actually had to have some questions about this. And it was probably too long ago and we've done too much work, but I did attach the city attorney's opinion to a an agenda of this subcommittee sometime last fall. I don't have my full file with me, so I don't have it.
It looks like, I'm sorry, board member Kit Sagamore had her name up for a while, but just, it looks like Kitty's written it broad enough to address that specific concerns about named officers, but it doesn't matter if they're named or unnamed. We just have this process now to handle.
I mean, the
these.
process could be, yeah,
It's
there's
broad.
nothing that says the process can't be broader and
Yeah.
cover complaints where they don't know who the officer is, but it doesn't come in on a complaint form, and that's fine too.
Right,
Right.
that's what I thought this was about. Somebody in the public sees something that concerns them. They don't know the officer's name. I mean, they might, but they don't necessarily. And
So-
so this is the process for that.
That's my
But is this,
understanding.
Kitty, is this always board initiated complaints?
I'm saying that the way it would proceed, assuming the board wanted to take it on, would be like a board initiated complaint or investigation, yeah.
Okay.
So, yeah, and that would allow for the confidentiality of the individual who came forward. I mean, I can easily imagine somebody seeing something that they thought was really wrong and not necessarily wanting to come out publicly with their name. I mean, not publicly, but, you know. And so this would allow an individual to file an informal complaint, which we could listen to and decide whether it merited opening an investigation by the board.
Okay.
And the example of the inebriated man, I think, is a good example. Had it not become public, we would have wanted to learn about it and investigate.
Chair, board member Sagamore has had her hand up for a while.
Yes, Ms. Saganor, and then board member Owens and Lieutenant Montgomery. Then let's try to see if we're going to add language, remove language or not, and then move on from there.
You're
Right.
muted.
There you go. Now I'm unmuted. I just wanted to address the question about, well, what could identifying features be that was not name or badge number? And to me, the answer to that is, cell phone video. I mean, you could definitely have, in fact, I've seen, video of officers where their name and badge number is not visible, but I can imagine that it's quite a clear picture of that officer so that officer could in fact be identified by somebody who knew the officers. I mean, video isn't always clear, but sometimes it is. That's just the point I was going to make. Thanks.
Okay. Board member Owens, thank you.
I guess for me, I feel a little uncomfortable about the other identifying features. I just feel uncomfortable about it. I'll just say that. I don't know if, I don't have a problem with people saying I saw XYZ, but I think for me, I'd have to have more than just somebody's features. I'd have to know this is where they were, blah, blah, blah. And maybe then you can figure out who it is. But just because they describe a person, I don't feel comfortable with that.
Okay. So you would remove that entirely?
Maybe
Okay.
add to it,
Or add to it?
identifying the circumstances, the date, time.
I think
right?
that's in the next phrase, and alleges any act of police misconduct. Lieutenant Montgomery has his hand up.
Yeah, Lieutenant Montgomery, next, please. Thank you.
Yeah, so the first part's just a question. So why is shall be treated confidentially stricken? Because if we have somebody identified, they still shall be treated confidentially. And then the second part is kind of more of a comment is, two things. One, the anonymous complaint process is not in the charter. And when the council approved the rule for the board to initiate its own investigations, the rationale given to the council did not include the process or possibility of anonymous complaints. So while we're acting on these rules granted by the council and sort of adding to them ad hoc as we go here, we should not be considering any anonymous complaints because that's not what was presented to council. Other reasons were presented to council, but not that reason.
Could I answer?
Yeah.
On the reason why shall be treated confidentially was stricken was because what was intended was it may be anonymous was added, and shall be treated confidentially was stricken because they were considered basically synonymous, but it was more precise to say may be anonymous if requested by the complainant. And
I'm going to guess that the confidentiality ties to the officer's rights, POBAR rights, if there being accusations being levied against them and their personnel rights. So I think it needs to remain in the final edit.
maybe,
Yes.
I mean, I don't know whether this section is necessary as long as we understand that board initiated complaints or investigations can be triggered by many different kinds of factors. What I'm suggesting with this section is that a board initiated investigation might be triggered by an informal complaint. Do you
Right.
see what I'm saying, Lieutenant?
Yeah, I understand that. I understand that that's a process you're trying to construct. It was not in the charter. And it wasn't one of the reasons that were given to the council when they approved the board's ability to make a complaint by vote of 5 board members. It was not articulated to the council when they made that approval. And so like between here and now, between here and final approval, if we were to take in a complaint and then vote for 5 board members to initiate an anonymous complaint, that to me does not seem like it's been approved.
Oh, I'm not talking about board members initiating an anonymous complaint.
So the person comes in with an informal complaint. They wish to remain anonymous. It's
Right.
reviewed at the next board meeting and the board
Yeah.
says, let's do it. Let's do a complaint. That's sort of what this is all describing. And so I think I'm just calling out the issue is that this rationale, this process imagined of a vote of 5 creating an anonymous complaint authority on the part of the board, I don't think has been explained to council adequately to feel like we're there. And
So-
I think it needs to be called out that we're creating that from whole cloth based on the prior PRC's ability to initiate an investigation where somebody was deceased or unable to participate for very different constrained reasons. So I'm just calling it out as a
Sure.
major issue.
Thank you. So, and Director Lee, so wouldn't that be a process that we could call out to inform the council that this is our intent because of this reason? And then they can either say, no, that's not cool, or we can proceed they could bump it back for further revision, for example. We could either flag it in the comments or put it in a set of notations in a cover when we send this over. Would that make sense, Director Lee?
I mean, you could do that. I would see this based on what Lieutenant Montgomery is saying. I would see this as something that would be flagged by the BPA for meet and confer. But the reason I raised my hand is I found the opinion. It's attached to your November 9th agenda, and it's dated February 15th, 2017. And this arose because we received an email from a member of the public raising specific concerns about a named Berkeley police officer, and I put it in the packet. And that was a no-no. And this was a legal opinion explaining why. And it was because any citizen complaint against an officer, even one that is not received on the official PRC complaint form, must be treated confidentially under Penal Code sections 832.5, 0.7, 0.8, and BPA versus City of Berkeley, the 2008 case. And the identifying features language comes from the opinion, which says, now I'm into the meat of the opinion, to determine whether an informal email complaint is considered part of a confidential personnel record of a peace officer, one must consider the content of the document and err on the side of considering it to be a citizen complaint with the associated confidentiality protections. And this is after the Ms. Van Herrick, who's no longer with the city attorney's office, had gone through an analysis of the penal code sections. An email sent to the PRC or PRC staff from a member of the public that identifies an officer or officers by name, badge number, or other identifying features and alleges any act of misconduct pertaining to the manner in which he or she performs his or her duties falls within the category of a citizen complaint and should be handled as a confidential document.
Well, I don't understand what, Kathy, no one is suggesting otherwise. I don't understand how that's relevant here.
You suggested striking shall be treated confidential.
No, that was, when I originally said shall be treated confidentially, I meant with regard to the complainant. And somebody suggested striking that and saying instead may be anonymous.
Oh, okay.
I certainly agree that with regard to the officer, it's of course confidential.
Okay.
Yeah, no, there's no quibble there.
Okay.
But I also want to explain why other identifying features is in here. It's not a requirement to file the complaint. It's something that triggers a requirement for handling it confidentially.
Okay. And could it be, and I also want to be aware there's 3 other people with their hands raised. Could it be that you're observing something, you're witnessing something, but you're not close enough to necessarily see the badge numbers and other identifying factors? You saw something happen that you think you have concern about, that's perhaps misconduct. And then you're describing like the race, the gender, the height of the officers involved and what intersection or what street it occurred. And then from there, they can try to garner additional information to figure out exactly what incident that person is referencing. Wouldn't that be a pretty straightforward interpretation of why that information is there? Why that language is there?
Yeah.
Okay, so we have with the specific language here, and we also have Lieutenant Montgomery has flagged this issue of the scope of our authority outside of the bounds of the charter, and we are going to have to consider whether or not to proceed with this and flag it for City Council, and there's going to be a number of issues. I think we'll just let them know. So I don't think that's the worst thing. There's some factors here we're trying to interpret our authority. I know it could trigger a meeting confer, but I think it's going to trigger a meeting confer in general. A lot of the stuff in here. That doesn't mean we don't want to be strategic about it, but this appears to be something that's relatively important in terms of independent police authority, review authority, is that if someone sees something, but they have concerns about remaining anonymous, which is something we have to think about, they should have an ability to file a complaint or file some type of report to the board. We want to think about that, the anonymous aspect of that too. But let's go forward with, I think, was it board member Leftwich or Saganor or Owens who was first?
I think I might have been, but I'm not positive.
I think it was
They're in the
Leftwich.
order. Aren't they in the order?
Yeah, I think
It's
it
in
was
order.
Leftwich, and it's in order.
Oh, that's interesting. Okay, yeah, go ahead with board member Leftwich, please.
Well, I think we're talking about 2 different things here. I think Kathy was talking about like when you need to keep things confidential, if it's identifying features. And I think the rest of us were kind of thinking in terms of what gives you enough information so that you can figure out whether or not it makes sense to pursue this further. And then I think perhaps board member Owens was concerned about identifying features being too vague or something. I won't speak for her, but I think Kathy, you were talking about something different than what we were talking about. But my other point is just, again, I keep coming back to this whole tension, and we're not going to resolve it tonight, about what's in the charter and what we can flesh out from the charter, because the city council did not consider every scenario. And they're the ones that ultimately decide about this. I don't think we need to flag it for them. I think the department is clearly going to flag it for them. And they'll be meet and confer. So the city council will be well aware of this as an issue. And I think we just do what we think is best. And then we'll take it back to the board and see what the board says, and then we'll see what the city council says. But I personally think this is what happens. I mean, I did a lot of work in the state legislature. The state legislature, I would attend the hearings. Certain scenarios would come up, and then the law is enacted and is applied a certain way. And someone says that wasn't the legislative intent. And who knows? It's hard to know sometimes what the legislative intent was. And so you have lawsuits and, but it's you can't say just because the city council did not envision this specific thing that it's not okay. We just don't know right now.
Okay, cool. Thank you. So we'll have to get to the point where we make that decision then whether we want to proceed with this language. Board Member Saganor.
I just wanted to follow up. I appreciate Lieutenant Montgomery's reminding us of what the council specifically approved. But of course, the council was looking at the interim regs. The council has not spoken at all on the permanent regs. And there were a number of ways, for instance, in the interim regs, it was agreed at council that how complainant would be identified to be so the person who was directly affected or a percipient witness, even though the charter language says the complainant is a member of the public that brings a complaint. So for the interim regulations, the council chose to give us something narrower than what the charter had in that particular case. And they might do so again in the future, but we really don't know what the council's ruling about the permanent regulations would be. Thank you.
Okay. Thanks. Board Member Owens.
So I thought I saw somewhere in the charter that it did say something to the effect of, I won't call it anonymous or informal, but it did say we could accept complaints from members of the public. It wasn't specific as to how detailed that was. And it is kind of in the interim regs that was approved. What they agreed to there, and I believe there was some conversation, was aggrieved parties as well as eyewitnesses, and that's when they were getting into that precipitant witness to alleged police misconduct may file a complaint. Complaints may also be initiated by the board upon a vote of 5 board members to authorize an investigation. So the way the interim regs were, that's what was agreed to in the interim regs. I understand we're working on the permanent regs. So I don't know. I could have swore I saw something in the charter that said something to the effect of accepting complaints from members of the public, but maybe I was getting mixed up with the.
No, they did. It does say that.
It does say the definition of complainant is any member of the public.
That's where I saw it.
Yeah,
I believe also in the interim regs, there is this section on informal complaints.
I think it is in there. I do think that is in but I was trying to find it in the charter because the question was, did the charter give us the authority?
Yeah.
So I was trying to say the charter, I thought I saw it somewhere in the charter.
Yeah.
And the charter does refer to the complainant as a member of the public.
Yeah.
So to me, it doesn't say the member of the public has to identify themselves. It just says a member of the public.
Okay. So that you think that potentially could include the scope of language here, since it's not identifying whether or not that member of the public has to provide their.
Well, for me, this section, the section is just a way to define what the board will do with a notification of or a complaint. If somebody of a member of the public tells the board, it's sort of like
which will happen.
Sort of like the incident that happened with releasing the guy from the jail. the public came to the board meeting, blah, 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 and then we agendize it, decide to investigate. So to me, it's kind of the same
Yeah,
concept, but I'm open to hearing everybody else's thoughts.
that makes, I think that's a good analogy to what happened with that recent incident. So I'm going to go to Investigator Norris, and then we want to try to make a decision about how to proceed.
I do think it's important that when we can, and I don't have any ideas here, when we can, we should try to avoid having as much conflict with the union and the police officers when possible. I mean, I don't think we should invite a meeting confer on multiple issues. I think we should try to reach an agreement or a consensus or something when we can. Having said that, I don't necessarily have a good workaround on this, but I want to get clarity from Lieutenant Montgomery. I understand you have an issue with anonymous complaints. Did you have an issue with informal complaints, though? It's separate from the anonymous aspect.
No, and we receive informal complaints all the time where somebody doesn't really want anything done, but they want some officer to talk to, or they don't want to go a formal route. They just want to bring it up so that something like that doesn't happen again.
Yeah.
That's normal. The main issue with anonymous complaints isn't that we don't think people ought to have a venue to air a problem or do that kind of thing. The issue is that they become very difficult investigations where you can't meet your standard of proof. They flood your office, they burden down the investigators, and then you can never, I shouldn't say never, they're very difficult cases to meet your burden of proof and bring the case home. And so consequently, you spend a lot of time, a disproportionate amount of time on complaints that are not going to amount to discipline. And they take away from your ability to handle cases that need to result in discipline. And so we have so many investigators, it's a caseload issue, it becomes a problem. And it's also where frivolous and antagonistic complaints live. So that's why I think the wisdom in the past has been to not allow them, because it can distract from important cases where the burden of proof can be met.
Chair?
Yeah.
Could I just say a couple of things? One is that I did make some phone calls around to the various other agencies that allow for anonymous complaints, which is all of the ones I contacted in the local jurisdictions, neighboring jurisdictions. They all allow for it. And I asked, is your office flooded with these anonymous complaints? And they said that they're very rare. That no, they're not flooded. In fact, they're very rare. So I would suggest that we allow for this, and the experience is that it doesn't flood the office from what I've heard. And the other thing is that the internal complaint process within the Internal Affairs Department of the Police Department accepts anonymous complaints by whistleblowers with the understanding that people can feel vulnerable when they make an internal complaint. And I think that the same logic can hold here. I mean, some people may feel vulnerable and want to remain anonymous.
Kitty, just if you happen to know, when you contacted the other jurisdictions, did you learn whether or not their boards or whatever their oversight entity is has the ability to initiate its own complaints?
No, I didn't. Actually, I didn't go that step.
Because that's a huge, the ability for this board now to be able to do that, I think is huge. It's much different from what the board could do when we were the PRC. I mean, that's
Right.
that allowed that.
It does allow that. I mean, in my opinion, this is one way, these informal complaints are one way that we could know about something that we might want to investigate. Doesn't mean that we'll investigate every one for sure. But I was wondering on the topic of these identifying features, I wonder if, Cheryl, you would feel better if the wording said or other precise identifying features or circumstances. In other words, if it was the example that Julie mentioned, a bike patrol officer outside Starbucks on 4th Street or something, would that be better?
Yes, I think I'd feel more comfortable the more you can identify, give more than just an identification. Because
Right.
like I said, people see officers in their uniforms and, yeah, I see them sometimes and get confused at who's who.
Right.
So
So-
I think the member of the public would, so I think you'd have to have a lot of identifying information. I also think that with these informal complaints, we do need to be careful about opening up the floodgates, I'll say, and being careful about, because it will be difficult, because if you have an informal complaint, my assumption is you essentially don't have a complaint. So when you do go to a hearing, you have no complainant to ask questions. Am I wrong, Kathy?
That's untrue. Usually the informal complaints are signed or at least identifiable.
Okay, but
No,
so
and
when you
we-
go to a hearing, is that person there at the hearing?
Wait, are you,
No,
Sharon, are you
no,
talking about informal anonymous complaints?
No,
That's
the
what you're talking-
informal,
Because informal complaints can include people who identify themselves. But so we're talking about informal complaints with anonymous filers?
Yes.
Okay,
those, I can't think of an anonymous informal complaint that was converted into a formal complaint that went to hearing.
Okay, so then basically
and-
what you're saying is you're calling informal complaints something where somebody files a complaint, they just don't use your form.
yes.
Yes,
Okay, all right, I understand it better now.
And so the big issue is whether or not to include in informal complaints the ability to file anonymous complaints.
right. And you should know, informal complaints were something that were, once this memo came from the city attorney's office in 2017, we set up a process and put it in the standing rules. And so there was a process with the PRC and the standing rules. I can tell you, we were not flooded with informal complaints. It was really a mechanism to deal with something that happened. We didn't advertise file an informal complaint, but people on their own, they learned, they were upset about something they saw and they learned about us, but they, for whatever reason, they didn't file it on complaint form. They wrote a letter, they sent an email. We had to have a way to deal with it.
So is this now not needed since the board can initiate an investigation? Is this-
No, it's still needed to handle those times when a member of the public complains about a specific officer. And so we need a process.
Okay,
Yeah, so I would agree with that. And my 2 cents on this is there's the gatekeeping function, which I know everyone is concerned about. There's like 2 sides of this. Open the gatekeeping function, or on the other hand, restrict it because you're concerned about flooding of perhaps cases that don't have merit. In general, I fall on the side of keeping the gate function open, keeping the gates open, and then you have procedures in place to vet out cases that lack merit, et cetera. They're untimely, they lack merit, they're insufficient in terms of facts, et cetera. You can't reach them, that type of thing. And it seems like you're going to get those type of cases, and you need some type of general guidelines for how to manage them. Now, it's analogous in some ways to our more, direct investigations that we could open up that we're talking about now, which I think is important to the authority of the PAB. But it's not exactly the same. Some member of the public is coming to you with information, and it could be a whistleblower or just someone in the context of a whistleblower is just worried about retaliation. I think that's perfectly fine. There's, inspector generals, this is the type of stuff they do. They have like anonymous stuff that comes in, or they may know who the person is who's filing the complaint, but then when they do the investigation, they redact and make kind of confidential that whistleblower's identity. So
No, but Board Member Owens asked an interesting question: is this needed?
Yeah.
And then I'm gonna go a little step further. Is this needed here? Is this worth? Is this worth the battle to put this here? Could we put it in the standing rules? I mean, staff can still do this.
So if you were to shift it to standing rules, can you guys explain it to all of us? What would that mean in terms of its viability and avoidance of a meet and confer?
Well, because what I'm seeing is just looking at the first part of this. I mean, we get communications all the time, and we've been handling them for as long as the PRC has been in existence. And we will contact the parties and let them know what the process is. I mean, that's standard. I mean, this only came up because we needed to find a way to deal with those complaints where officers were named, and we needed to protect the officers' confidentiality and privacy, because this thing was considered, a potential complaint by the city attorney's office. But I don't know, Kathy, you can tell me, but I don't see how. I'm questioning why this is needed in these interim regulations, and is it worth adding another battle to this process to get these regulations approved?
Well, to answer Chair Chang's question, I don't think moving them to the standing rules will remove any need for meet and confer if whatever is done to them triggers meet and confer. What we had in place in the standing rules before did not trigger meet and confer and was fine. I think so. I just thought it made more sense to have all complaints handled in one document, which is the reason I moved them over here.
Oh no, I agree with you directly. It's just that I'm trying to find a way and urge us to find a way to find some middle ground when we can.
Well, moving them, if we keep anonymous complaints, and if there's an issue with that, it doesn't matter where these.
Or they don't have to be in standing rules. It could just be our practice. But do we need this formalized here? Because there was an agreement for a complaint process. I mean, I'm struck by the comments that the lieutenant made. There was disagreement for this process, for formal complaint process, and now we're adding in this other thing. So I'm just impacted by those comments.
Okay, thank you. In a way, I appreciate the kind of investigatory feedback on that too, of what could slow down the process. But in terms of meet and confer, I think we all agree that because these are significant changes that are tied to the charter, the union already has concerns and already triggered concerns very early on about the charter to begin with. And these rules are going to trigger a meet and confer. I don't think we should be afraid of that. We just go through the process. And I think Chair Ramsey was talking about this previously with me and with the city attorney's office. It's kind of like 1973 when the PRC first came on board, initially as a new oversight board. There's a lot of litigation and back and forth about it. We're not exactly in the same situation, but we are in a situation where there is a new entity with additional authority, modernized authority, is going to trigger a conflict, and we have process for managing that conflict. And who knows, it might go through process, and then they might say, we'll keep it in, or it'll be significantly modified, or it'll be removed. So long as that process is there, I think it's okay. I mean, I think because of the aspect of whistleblowing / gatekeeping and the fact that it's going to come in the door, you want something there to address it. You could leave it in practice, but leaving something in practice opens you up to like inconsistency and accusations of a whole range of stuff, I think. So my preference is to keep it in here, maybe modify the language as much as we can. I just want to do a time check too. It's been a little over an hour, so it's 7:57. we have less than an hour until 8:45 when we should stop. So just to bear that in mind. So we're at page 21 of 22. I hope that we can get through to 22 and then maybe even start at the top, but we may not get there. At a minimum, we should get through page 22.
We're almost there.
Yeah.
Yeah.
So let's try to push through and make a decision, though. I know we're talking it out. That's really good, but we really have to decide, are we comfortable with moving forward with this language here, given what Lieutenant Montgomery has flagged, Director Lee and Investigator Norris, and all the other input that we've received. Board Member, I think Owens, and then Board Member Leftwich.
I just have a quick question. So can somebody clarify for me if this language was in the PRC's regs?
No, it was in the standing rules.
And can you explain, Board Member Lee, the difference between the standing rules versus the PRC regs?
And before she answers, the anonymous language was not in the standing rules.
Just the
Right.
informal.
Just
informal.
informal.
So
Yeah.
the informal language was in the PRC's standing rules.
Right. As a process, as a basically
Working
to
process.
describe the process.
Okay.
So then I guess I would be comfortable if it was what was, formalized before.
Well, not all of this process was in the PRC standing rules. For example, we didn't bring this to the board to initiate a complaint, for example.
Sure. So that's a little
The
bit.
original language,
Yeah.
yeah, I mean, it's hard to,
So this exact language was
this
not.
exact language was not in there.
But
It
in
was-
spirit, it's generally the same, right? Someone comes in with a informal complaint, and they might want to maintain anonymity. We allow
No,
some process.
there was
No
no
anonymity at all.
language regarding anonymity.
So our add-on is the anonymity aspect.
That's
And
the big add-on.
Yes.
yes, so I think that aligns with, just make sure we understand this, are on the same page, and then decide to agree or disagree. In terms of a modern police accountability board, anonymity falls in line with the work of, say, inspector generals, and agencies or sub-agencies that protect against retaliation, whistleblowers, and also provide for that space and the gatekeeping function of allowing that subset of complaints to come in the door. And I was a state inspector general before. I didn't see a flood of those type of cases. I do see the concern. You could sometimes have somebody, but it would have to be very specific circumstances, who sees something systemic, but they have to have some individualized witness testimony here too, witness information to say, like, on this day I saw this, versus the type of cases that can tend to clog up things is like someone looks systemically across all universities across the country, and all of their websites are inaccessible to individuals with disabilities. And in general, a number of years ago, that was a problem. And then they just start punching out, and they could, if they could do it anonymously, maybe that would make it difficult to investigate. But at the same time, you have individualized facts. You're going to the websites of the particular universities to ensure that they're compliant with accessibility laws. So I think that concern, yes, it's always going to be there with any type of complaint. But I don't think this is the type of case where you're always going to have a situation you have no information at all. And if that is the case, we have procedural and standing rules, or procedural rules, investigatory rules that can allow us to throw those cases out. So, Board Member Leftwich, you have your hand raised still?
You're muted.
You're muted.
Two things. One, I think we should include this. Again, we're going back to the full board. We will discuss it again there and then city council, but I think we should keep it. But my other point is that, so this section is informal complaints, and then section 2 is formal complaints, but definitions, we need to tweak our definitions then to reflect those two different types of complaints. And I know we'll go back to the beginning, but just to flag that, we now say complaint and complainant who files a complaint. And we need to, my recommendation would be to say, have a definition of a formal complaint and a definition of an informal complaint. just so that we're being consistent.
Okay, so are we under the presumption we're going to proceed with this language and tweak it a bit here?
We're striking the anonymous, right?
We're striking and or anonymous in the heading. Yeah.
And what about may be anonymous? Such complaints may be anonymous. Further down.
Yeah, I think that's important. I
To
mean,
keep
that's
it-
what we're talking about.
Right.
But I would add, instead of simply or other identifying features, I would add, in order to address some of the concerns, other identifying features or circumstances, you know, trying to make
How
it a
about-
little.
Yeah. I guess I'm not as concerned about, I think the circumstances, like date, specific circumstances, maybe put in the word.
Okay, either specific circumstances sounds good.
Yeah.
Specific circumstances, that would be good.
Because we're trying to address like the problem of like non-specificity, making it difficult to
Right.
investigate something like that.
Right.
Okay, specific circumstances. Yeah.
Do people think that we need a statement at the end of 4A clarifying that, of course, these are confidential?
Yes.
Yeah, so such complaints may be anonymous if requested by the complainant. No, I wouldn't change that, Kathy. I was going to add a sentence.
Okay, well, I was gonna cut and
Well,
paste this, but that's okay.
Yeah.
Okay,
All right. How about and shall be treated confidentially? Can we put that there?
yeah, sure.
And shall be treated. Okay, yeah. So is everybody okay with this language here?
Yes.
We
I
want
have-
that many ors.
Well, I don't get a vote.
Identifies, what?
I don't get a vote. What is, you asked if we were okay.
I think
As we-
Stop
those
that.
words are okay.
Everybody,
think-
are we gonna do we need to do a vote on this or is it something that, I don't think we need to be that formal. Director Lee, what do you think?
No, I think you're just acting by consensus, and then at the very end, you're going to approve a document to recommend to the full board.
Okay,
And if there's people who, at that stage, if there are people who feel strongly about any particular thing, they're allowed to submit a minority report.
oh, that's exciting, minority report.
There's,
Now, on the last section, I just added, or I can't remember, I think I added the hearing follow-ups to be consistent with what some people,
oh, I'm not done, I'm not done with this section.
I'm sorry.
Yeah, let's make sure we finish that, but let's keep it track of time. I really want to, for our kind of like feeling of getting stuff done, at least get through page 22. So we have about an hour, less than an hour, like 45 minutes.
Oh, 22 is nothing. It'll take 5 minutes.
Okay,
Okay,
so
so
yeah, tell us what you need us to.
here in C, it says, if the complainant wants to go forward, it shall be agendized at least 1 week before the meeting. You all know the agenda goes out about 5 days before, so can I put that? Can I put 4 days? Every now and then, the agenda doesn't go out until a Friday, but usually it goes out on Thursday.
Okay, so you want to shorten the time frame to give you a little more flexibility. I think that's okay.
To conform to actual practice.
for
Yeah,
actual practice.
that's
And
good.
I think that's okay with me.
Okay, thank you.
As long as that's adequate notice for the complainant, but presumably they're agreeing to that.
Well,
So you mean
there's
calendar
nothing
day?
that we can notify the complainant ahead of time. It's the agendizing part that
Oh,
I'm concerned about.
right.
Board Member Saganor has her hand up.
No, I'm
Oh,
sorry.
that's from before. That's okay.
Quite accidental.
Okay. So we're moving on.
Nodding along here.
Which section are we at now? So
Let's see if everybody is good with section 4.
Can I ask a question about D right there, 4D, where it says the board shall consider the informal complaint Oh, okay. All right, I answered my own question.
Yeah, anonymous has been removed there.
Actually, I have to put back all this stuff about closed session. Too, remember? So I'm gonna
Yep.
delete this.
And distributed to the board in closed session with notice to the named officers. You're going to put it back in?
I gotta put it back in, not delete it.
Yep. So you have to reject the,
Reject the deletion.
Yep.
Okay,
good, that looks good. If requested by the complainant, the complaint will remain anonymous. Okay. I think it looks okay. The board shall consider informal complaint, and upon a majority vote of board members may initiate investigation. Board member Leftwich has her hand raised.
I'm on V, so I'm hearing follow-ups. I don't know if we're there yet, but.
Okay, you're just getting ready. You got your hand up early. And so I think D looks good to me. Does anyone have a concern about it? And E is looking at E right now.
No, let's go back to D. Let's go back to D. I have a question.
Okay, let's take a quick look at D again.
Yeah, real quick. It says if the board shall consider the informal complaint. No, wait a minute, it's E that I was looking at. If the board votes to initiate the investigation, it will retain the anonymity of complainant. Now, I thought we said we were getting rid of anonymous, that we were just dealing with informal, which with the informal, you said people are identified. They just don't.
We're just deleting anonymous in the heading and throughout where it's repetitious. But
They're not getting rid of anonymous.
if requested by the complainant, the complaint will remain anonymous, as you see in letter C, for example. We're allowing for the anonymity if the complainant requests it. It's just that we've deleted that language where it's repetitious, like in the heading, informal complaints.
Maybe you should go back and show board member Owens where that anonymous is going to stay. And you then, if this is not agreed upon by consensus, you might have to vote on this if she's
Yeah.
not.
So for A, you see the last sentence in A, such complaints may be anonymous if requested by the complainant
Oh.
and shall be treated confidentially.
So that's new, right? The anonymous.
yes.
No, it's not new. I mean, it was there.
It doesn't exist now.
Oh, as in, it wasn't in the PRC, yes.
Yeah, and it's not in the interim regulations.
So
either.
yeah.
Can I throw in a wrinkle there? We do an investigation following a complaint made at the DPA. RIAB takes up an investigation, and that might give the impression that the existence of the complaint will be handled confidentially, because we're trying to sort of blend the needs of the complainant and of the officer in that one sentence. It might need to be two sentences,
I was
because
thinking,
we're still going to find out about this investigation for this complaint, right? The department's still going to find out.
That's
I
a
thought
good,
so.
I don't know.
Well, I thought the department would know about the investigation. It's just that the person that raises the complaint is the anonymous body. That's
Right.
what I thought this was saying, that the
Yeah, I just think saying
complainant's
shall
gotta
be
go to the
treated
department.
I think because we're trying to cover the officer with the shall be treated
Right.
confidentially, but if we're
Right.
telling that to the complainant, they think nobody's going to know about this except for the DPA,
Right,
potentially.
yeah.
See, that
Right.
raises a larger issue for me. I think if we're going to keep this anonymous language, I just think it needs to be more fleshed out. I don't like just throwing it in there. You know, we just need to get this.
what do you mean fleshed out? I don't see what,
Well, like the question the lieutenant raised, I mean, we don't know whether we can just provide, I mean, I don't know if we're going to be able to retain their confidentiality once we send it out the door.
So the confidentiality is meant to apply to the officer, and I think that's what Lieutenant
I'm
Montgomery
sorry,
was
I mean,
saying,
I meant
is that there
the,
were combining things in that sentence, and maybe we shouldn't combine them.
But I don't
Because
think we
the
can-
complainant might think, oh, it's confidential.
Yeah.
She split into
Right.
two different sentences to specify.
Yeah. Or the officer's
Or just add, yeah,
identity shall be
confidential.
confidential. Yeah.
Well,
I thought we were talking about the complainant's
it's more-
identity, protecting the complainant's identity.
That is on the anonymous side. The next sentence we want to add is the confidentiality of officers, of the officer or officers will be preserved.
Okay, how about something like that or a clause? Does that make sense to everybody? Let's see how it looks.
The confidentiality of the officer will be preserved, shall be preserved.
That's the way it is
Wait.
worded.
What happens when, unless, Lieutenant Dan, was this answered for you? What happens when we get the anonymous complaint? And if it's accepted by the board for an investigation, and then what do we do with that in terms of the department and their parallel investigation? Was that answered for you, Dan?
No, I have a bunch of questions about that.
Yeah.
If now sometimes we'll know about an incident, and so we'll know who the party is because we identified them in the incident. But sometimes the complaint won't be attached to an incident, and that can be problematic. Just trying to investigate the incident at all, and that's why I was saying earlier that confidential investigations where a person doesn't sort of see the process through makes it really hard to meet the standard or really investigate. You sort of investigate into a lot of dead ends. But
Because once we start the formal complaint process, it goes to IA and they start investigating, and we have given them the information to probably identify the complainant.
and we're going to want to reach out and conduct our interview
Yeah.
with the complainant. So the complainant should not be, I think, given the impression that the police department won't know about this and won't be reaching out, because that is very much our process.
So Lieutenant, so in this situation where the board launches its own investigation, as we are doing, for example, with a couple of cases now, I mean, I was imagining that this would proceed. In fact, it says so in D, may initiate an investigation. Why can't this be handled in the same way that any board initiated investigation would be handled once it gets to that point?
So
In
I
other
think
words,
it's,
why-
I think it's probably handled several different ways. In the case of where it sounds like it's more something like a policy complaint, then it would be handled in those rules. If it sounded like it was a situation where it's like, we have no idea who did it, but we know something happened and we need to go look into it. It could be that the board just wants information generally, and maybe there's a process in between that isn't the board launching an investigation against the allegations against specific officers. Right now, you're saying we don't know what we don't know, and so we want more information. There could be an in-between type of procedure where the department comes back and tells you what we know already, and then you say, okay, now what we know, we don't want that investigation. I don't know what that looks like because it's new to us.
I'm not following you too well, but I'm imagining someone who comes forward and they're not the aggrieved party. Possibly, they're not the aggrieved party, but they witnessed something and they come to us and they tell us about it and they give identifying features and the circumstances, and we vote to open investigation into it. Why couldn't we then notify the department that we are opening an investigation into this incident?
I think they would.
It
And so
will be-
what I was
they-
pointing out,
Why would we
Will
have?
be notified. Anytime a formal complaint is initiated, we notify the department.
Right. My
what
point
I was
is,
trying to untangle is those two ideas, the confidentiality of the officer and the anonymity of the complainant, read like confidentiality and anonymity for the complainant if the complainant were reading those rules. And I just wanted to untangle
Right.
that so that we could be clear that the department will still be notified. There will not be confidentiality about the existence of this
Right.
complaint.
And so we changed that. So now
Yeah, I think that's untangled now. But when you
However,
talked about the case,
I
with,
still think that when the complaint comes to the department, it will come as a board initiated complaint, and there would be no reason for the department to have access to the identity of the individual who may or may not have been the aggrieved party to be named. Why would that be necessary?
these are exactly the kind of discussions that really need to be had around this. I think that Mr. Norris is pointing out. Yeah, maybe you make a good point. Maybe it totally is worth discussion. The other thing I was trying to talk about a little bit is the situation with the guy who was inebriated and passed away. When that came to light, the board said, we want to look into this, but you didn't say we're filing a complaint against officers XXX and Y or something. So that makes it sort of a different, we're in a different zone in that first fact-finding phase where the board may just want the initial findings before they actually make further decisions about complaints against officers. So it's
Right.
like about looking into a situation, complaining about a policy, or making a complaint against officers could be very different processes that are maybe special situations depending on how we handle them. But when they imply the rights of the officers, they're going to obviously have to conform to all those processes and protections of the employee.
Well, I have a question. So are we saying that somebody comes to us with an informal complaint? This person says, I want to be anonymous. Now, it is a complaint, so now it's going to go to the department for them to investigate as well. Now, when you guys are saying what you're trying to put into this regulation is you're giving the complainant the opportunity to be anonymous. So when it goes to the department, they don't know who the complainant is? Is that what you guys are saying? Because to me, how is the department supposed to investigate if they don't know who the complainant is?
That's obviously a concern for us.
I'm not sure what difference it makes who the complainant is. They may not be at all the aggrieved party. They might be a passerby.
But the department would still need to, when they do the same way we would need the information from that person when we do our fact finding and investigation, so would the department. The department would also need to be able to ask that person questions. And I just think the department would, if we need to be able to ask that person questions, why wouldn't the department be able to need to ask that person questions? So how could you give the department only part of the information? And then, we have more information than they do. How do you think that they're going to be able to do a complete investigation without having access to ask the person that brought it forth what the issue is? I don't see how that can happen. I guess what I'm saying is I don't see how that person can be anonymous to the department.
I mean, one thing is, I guess, if it's in front of the Pete's on 4th Street and it's a bicycle officer, they could talk to the officer and ask if anything happened. I mean, it is obviously more complete if they're talking to the person who made the anonymous person that made the complaint. But if there are enough specifics provided, and that's why it's got to be very specific information, the date, the time, where it was, what happened. And then they could go ask the people at the Pete's, did you see anything?
Okay, so let me reverse this. How would it be if the department had all of this information, including the complainant, and then gave us all of the information except for the complainant to do our investigation? How would that be? Would we be able to do a proper investigation without knowing who the complainant is? We have all of the information that you're saying, it was in front of Pete's, it was this time, it was a bike off, whatever. But would we be able to do a complete investigation without having the complainants be able to ask questions of the complainant? Because that's what we're asking the department to do. So that's the only reason why I'm asking that question.
I think you have a good point. I think that I was thinking more in terms of someone coming forward and relaying to us an incident. not necessarily misconduct by an individual officer, but relaying to us an incident that they witnessed. And then we would choose to investigate that incident, much as we're doing with the couple now. And in such a case, it doesn't seem to me that, I mean, we would investigate, we would probably ask for witnesses and so forth, but I don't know that the identity of the individual who came forward because they happened to see that would be that integral to our investigation.
If they saw it, then they are integral because they are a witness. If they saw something, they are a witness. So they would be integral to your investigation. How would they not be?
Maybe we could give the department, the person's statement with their name redacted. So you know, they're not, so they would have some information. But yeah, you're right. They would be limited. They wouldn't be cross-examining the person. I'm just wondering if all this should go under investigations initiated by the board. If that's what this is.
Well, that wouldn't solve the problem of anonymity. If we want to preserve.
No, I know. Right, but if that's what we're in, if that's what this is all about.
Well, it's also allowing for informal complaints to come in. Like Kathy said, you know,
Right.
they do happen, and therefore we need a process for how we deal with it.
Yeah.
And I don't know, I mean, maybe people think that this is more of a thorn than is worth it now that, I mean, I frankly hadn't thought through it coming to the department.
But I think this, for me, the sticking point is that anonymity for the complainant.
Oh, I know. That's what we're.
So
Yeah.
if we eliminated the ability for the complainant to be anonymous.
Yeah, well, that's the whole thing, isn't it? I mean, I was trying to make it possible because I think that there are differences of opinion about this, but there are people out there who feel nervous about complaining about the police. And I wanted to allow for some way for that to happen.
How about if we bring this forward, because I don't know if we're going to solve this. Why don't we go ahead and bring this forward and just flag it for the full board that these are some issues, and then have a full discussion and see what the full board.
Well, these same things will be rehashed there, you know.
No, I know, but then we can take a vote of the full board and see what everybody thinks. But my own vote today would be, let's go ahead and push this along, acknowledging that there are some potential issues with it, and maybe ultimately we won't include it.
Yeah, I think that makes sense. Does that make sense, Director Lee?
Well, if we just want to move on, yeah, it makes sense. And I understand we spent a long time on this, but this is a big issue, this anonymity thing.
Oh, it is.
For me, if I was in your role as a board member, I would want more information. Kitty said she reached out to some jurisdictions, but clearly we need more information. How do they handle this? How do their police departments handle these investigations? What sort of safeguards are in place? There's a lot of questions that we don't have, and we're trying to solve a problem that I still would like to know. I'm still not sure how big that problem is in Berkeley. Not that there aren't concerns with filing complaints against police across the country, but in Berkeley, in my 12 years here, I haven't gotten many people come to me and say, I'm scared of filing a complaint. What I've gotten is, I don't know the PRC existed.
Well, but maybe they didn't come to you because they were scared to file a complaint. Maybe that's why you didn't see them.
What I'm saying is we have data. We have our own outreach subcommittee last year that did a poll. The Reimagining Task Force did a poll, and they asked about the police. The police was not their concern, and we just ignore our own data. But I'm not saying we shouldn't ever do anonymous complaints, but I just think, does it have to be now? Is it worth fighting over this when we haven't established a need for it in Berkeley?
I should also say that it is on NACO's list of best practices for oversight agencies.
Yeah, NACO has a whole bucket list of things and you.
No, well, I mean, 10 maybe. I mean, not,
Yeah.
you know, so this was something that NACO believes is fundamental. So I don't know how agencies deal with the issue of,
So we have
yeah,
have some
anyway.
mechanical issues to address, but I think from a principled standpoint, it is part of modern policing, and it falls into that modern and independent review and policing. It also falls into that aspect of whistleblowers. So we want to. I feel it's important as a PAB to put that on there, but perhaps as Investigator Norris suggested, to have a meeting where it goes before the board and maybe invite some of the other independent oversight committees that come and talk to us about mechanically how does this work for them, and does it gum things up, or are there different things to look out for given that principle, and then from there the full board will have a vote after they have had some exposure to how other independent oversight commissions actually run this. It probably would be helpful if they came with the relevant police departments too. So the two of them could explain that, yes, this has been helpful or it hasn't been helpful, and this is the pros and cons of it. Would that actually be something that we could do, Director Lee?
You could do it. Obviously, it's gonna take more time.
Yeah.
Lieutenant Montgomery has his hand up.
Yeah, Lieutenant Montgomery.
Yeah, I mean, I think there's a difference between sort of the department's position on the mechanics of how a complaint moves across to the IA and those kinds of things. But the kind of issues and concerns I hear about officers, maybe that gets hashed out in the inevitable meet and confer over the issue. But, you know, they're concerned. There are people who follow police officers around and have a problem with every single stop we make. And they're concerned that those people will turn into habitual complainants. I mean, when we're going through this process, we're applying a lot of goodwill to the complainant who's coming forward. And, you know, that's a big thing. But not all complainants have goodwill. Some complainants file frivolous complaints, not to say that all complaints are, but some complaints do. And there have been issues of people who complain every time the police are called out to deal with a problem at their house. And so, you know, anonymity is I think where those types of problematic complaints will learn. And I points well taken that you do have ways of handling that when it's available to you, but it's where those kind of things could potentially live. And Kitty's right. I don't know that we would get a flood. I don't think we have a flood of complaints anyway. But officers, you know, it's a big thing. We take our work very seriously. And it's a big thing to get a complaint and go through a process of a complaint. And we want, you know, the officer wants to feel like they're being treated fairly as well in this process, right? So that's why all the concern around it. I think it needs guardrails. I think it needs to be fleshed out. Otherwise, it'll become the subject of a lot of process, which obviously is acceptable. But there's an opportunity to do it here, or to give more consideration.
Lieutenant, could I ask you just one? I know we're trying to move on. But I believe that I read that Internal Affairs has a process for anonymous whistleblowers, where an officer sees another officer do something they believe is wrong. So
that's every employer in the state of California has a whistleblower law. So it's not 100% overlap, but yes, absolutely. If somebody makes a complaint and as a whistleblower, to the extent possible, the protection could apply. Sometimes people know who was at the scene of that situation, and it's not realistic.
So how does that anonymity get preserved, given that there has to be an investigation? I mean, is an analogous process to what we're talking about. How do you make an investigation when you can't name the whistleblower?
Is it?
I don't think it, in most cases, I don't think it realistically can. But in instances where it can, and the department is obligated to, obviously we would follow the law.
You have a Lieutenant Montgomery. Does that mean you have a firewall established around it, And is there a certain set of investigators who will conduct the investigation who?
No, so there is an anonymity around the IA investigation, period.
Right.
The only thing is that the person who is being asked questions could make inferences about why they're being asked certain questions and who could have witnessed certain deeds or whatnot. So depending on how removed from the situation that whistleblower complainant was, would probably, the further they are from the situation, the more likely to be able to preserve anonymity. So it really kind of like, it's very fact specific. So I don't see that as, in the Venn diagramming having quite as much overlap. This would be sort of distinct for me, especially given the fact that we couldn't follow up very well on the investigation if we weren't made aware of who the person was, and we could not find that information out ourselves, as Mrs. Owens brought up.
Board Member Leftwich.
I guess what I was going to say, just in response to what Lieutenant Montgomery had said a few minutes ago about, some people just hate the police and they'll complain all the time about everything, is just that we have a staff who's used to dealing with that, and they can ferret out the frivolous complaints. So I think we need to defer to them to vet the complaints and to not give ones that are obviously frivolous or people who just can't stand the police, to dismiss.
Oh, Julie, would you be comfortable giving staff the ability to make that decision without taking it to the board? Because I would be okay with that.
Well, you guys do that. I mean, if you think you make recommendations, right?
Oh,
And so we defer to you on a lot of those recommendations. You're saying just unilaterally.
If you get, because that would make it easier for staff to deal if we did have an issue with a bunch of frivolous complaints coming in,
Right.
and not having to agendize that for you all and do the work around that. But yes, I mean, that's
Something to think about. I hadn't thought about that, but.
those are the kinds of things that I would like us to.
Or like dismissal is.
Right, right.
Well, that can be
Yeah.
another.
So can I make a suggestion?
Yeah.
Maybe, well, I think we need to think this through a little bit more. Do some research behind it. And then I think if we're going to put this in there, I think that we ought to put some sort of parameters around it and identify when something goes forward and when it doesn't. So basically kind of identify when things are, and you can't identify everything, but something that would be considered frivolous or retaliatory or something, but just put some boundaries around it in this regulation as to what, and if we put boundaries around it within the regulation, I think that would help this process. Because I think part of it is right now it's just kind of, somebody can come in and make an anonymous complaint, but there's that concern of they're just going to come in with something frivolous or something retaliatory or whatever. And I understand the desire to have anonymous complaints, but I also understand having some boundaries around what those complaints are. And we also have to think about the department's own investigation. And, if we don't pass them this complainant information, and especially if you're saying the complainant's going to come in with specifics, how are they supposed to do a full investigation themselves? So I think we beat this thing to death tonight. I think we should move on and recognize we got to come back to this.
Okay, so let's say we recognize, let's come back to it, and let's have some objectives in mind with more narrow tailoring to what we're going to do the next time. So one is a little bit more research on this, but I think that might need to involve like either having conversations with folks or pulling a set of information. Like maybe Ms. Calavita can direct us towards websites of these oversight committees. We review their policies and procedures with how they implement this. And then we could invite to the regs committee some of these folks. Do you think that's worthwhile as a next step to address this? Because this is kind of a thorny issue. And I think it's not just going to be us looking into it and adding language, but maybe hearing from these other independent oversight commissions in terms of how it has actually functioned, and maybe with the police department too, I think would be helpful.
That's a good idea.
I like that.
It's gonna mean that we're gonna have to schedule that, and it's gonna put us beyond, we thought we were gonna finish in 2, but
I
Yeah,
think that's going to take too much time.
it's gonna take time. That's the only drawback.
I think we need to, yeah.
Kitty,
So-
would you be willing, since you're the one that knows the most about this, just to do a little more research to see if you can figure out how this works, you know, in the real world? You feel like you've kind of exhausted your possibilities.
Well, I've called these people. I called Oakland and San Jose and San Francisco and the ones and San Diego, for that matter. I spent quite a while. I had a Zoom with people in San Diego. And I mean, the thing is that each system is slightly different.
Right.
And
Sure.
most other systems don't have review panels or hearing panels or, and, you know, I could try looking at websites and so forth. You know, I could do a little bit, but I suspect that to the extent that internal affairs is going to want names of complainants on these informal complaints, I don't see how we can guarantee anonymity. I mean, if that's a non-starter, I don't know.
Maybe, could that be just a direct question that you or we ask these independent commissions, other commissions, like what happens when it goes to independent, the IA? How do you maintain anonymity? How do you address this issue of anonymity?
Mhm. Yeah.
Would it be okay just to even follow up with an email to those
Sure.
parties, and they could look at policy section, blah, blah, blah. And then board director Lee could, I'm assuming we can't all be put on the thread, but she could forward the results to us or to you, and then you can forward to us, or
But we can, remember
We're not
you
subject
don't
to the
have
Oh, that's
follow
right.
the Brown Act.
we can do whatever we want. So you can
Well-
put us all on the thread, and we could even follow up with follow-up questions, and that's outside of a committee process. Is going to be on email. Is that okay too? Because it's out of the Brown Act.
Yeah, it's fine. It's a committee.
Okay, that's really good.
Subcommittee.
How about that? I mean, I think that's an effective way. Like we could agree upon like the 2-3 questions to ask them. I don't want to put a lot of work on on you, but you already have to engage with these folks and you say, what happened? We're concerned. We are looking at this closely. We're concerned about how anonymity is actually preserved throughout the process from the review panel. And you can just very briefly say this is what it is as it shifts over to an IA. What
Yeah,
happens
I'll do
with
that.
your commission? Yeah. Well, are there any other questions with regard to that? Like the flow of the anonymity, and then
I
the
think that's
police
the-
officer.
That's where the rubber hits the road.
Yeah, that's the
Right.
main question. I just want to make sure so we tie everything up here. Anything else aside from the rubber hitting the road question? Is there a confidentiality question for officers, Lieutenant Montgomery, that you think you should follow up on?
I mean, I think I kind of covered the concerns I
Yeah.
hear is that there's
Okay.
people that actually look for things to complain about.
Yeah.
And if they had the ability to do that, we think they might.
Okay.
I
And then
can vouch for that on my side.
sure, we do. I know that there are some, complainants that are filing complaints. That's part of the process. Like you're going to get that, but if you go the other route and you narrow it, then
No, I don't mean
you
like
know-
good actors with grievances. I mean, people who professionally follow the police and
Yeah.
look for grounds to complain.
Yeah, I understand that. So one thing we could also talk about as a follow-up to this is Investigator Norris said, can we consider like allowing discretion to investigators to dismiss on certain grounds?
To the
We have
DPA
that
staff, I
already.
wouldn't say investigators, but definitely to the DPA, the director.
The DPA, I'm sorry,
Yeah,
the DPA to dismiss on certain grounds.
That's already in the regs. We don't need to revisit that. We already have frivolous or unfound or
Those are
those get brought
administrative
to you.
closures that have to be brought back to you all. And what I was asking for is
oh, I see. Yeah,
DPA.
give the staff the ability to say up front, no, we're not going forward with this.
What do you guys think? Does that need to?
I personally think everything should come before the board.
Okay.
And I think that you just write a real brief one sheet. This came to us, we deem it, blah, 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 for this reason, and then that's it. But I think everything should come before the board.
Yeah, that's a good point. I do see your point, Investigator Norris, like in certain circumstances in my work life, you go through the dismissal process pretty quickly. And it takes care of some of the caseload and you can focus on the stuff that has merit. It's tricky here because we're an oversight committee. And if someone could say, oh, you just dismissed 25% of your caseload. And this actually happened to my agency that I work for, and the lawsuit ensued. They said they must have put in place protocols to kick out cases that actually some of which may have had merit. So that's part of that problem that could emerge, is the whole gatekeeping function and being overbreath in your response. But I totally understand that.
And I'll just say, I understand that this body wants anonymous complaints. I understand that. I understood that a few meetings ago. What I was just trying to get us to was a place where we can at least get a more fleshed out process that is balanced in some way, that addresses concerns from the police department, concerns from staff, and allows the complainants to file anonymous complaints, and not just simply just throwing it in there. That's all I'm seeking.
Yeah, that makes sense. So I think that's a good
It's
route.
a comprehensive, well thought out, smart, anonymous complaint process if we're going to do that.
Okay.
There are places in the charter where the DPA office has gatekeeping functions also.
The DP has further, yeah. So that's important.
Well, they could do it for well, we'll talk.
So does everyone agree then the next step is board member Calavito will put us on a group thread with some of the folks from the independent commissions that ask us questions?
Wait, I don't know why it has to be a group thread. I was going to just email them personally.
Yeah, you can do that too.
Answer to that question, and then
Yeah.
I'll respond to you. I don't think they want to be on a group thread.
No, I think that makes sense. You're right.
Yeah.
I was too excited.
Are you saying they want their anonymity?
That's right.
And confidentiality.
They're as swamped as we are. I don't think they want to.
Right. I was too excited to get to know other commission people. So just put it on there and then forward it to us. And if we have follow-up questions for you, maybe you'll bump it back over to them. And I'm sure like looking at the policies and procedures will help at that point too. Great. So it's now 8:45. So we've hit 2 hours. Is there anything else we can need to do maybe in like 5 minutes? I don't want to wear.
Well, I had something on the hearing follow-up that's pretty discreet.
Okay, let's look at that, and then let's try to end that. We're basically at the end of the document.
Yeah.
Where's the hearing follow-ups?
It's V.
Number
Right
5.
there.
Okay, so we're down there now. I'm just trying to.
Yeah.
Okay.
So I was happy, and I think Kitty added this language about the last 2 sentences. If warranted, the complainant will be directed to relevant resources. The complainant may also be informed of potential policy reviews related to their concerns. So I like this, but the way this has come up is more in the findings, like when we tell the complainant what the results of the hearing. That's the point where I would like to say, and that's on page 18, but maybe we put it both places, because it's participation is optional. So if they get a bad decision, we find the complaint to be unfounded, and it's like, well, do you want to talk about it? It's like, no, I'm upset about it. But so my idea would be to put it in the whatever document they get with the results of the hearing that says, we did not find in favor of you on your complaint. However, we appreciate the fact that you've highlighted that this particular policy may need some review. And we also wanted to point you towards these resources or something there. So I like the concept. I just think it should be incorporated in what we tell the complainant after the hearing as well. Maybe both places, but certainly in the earlier as well.
Okay, so how would we, is there any changes here then to allow for
Well, so
that?
page 18 is deliberations and findings. Content of findings is 4.
Okay, page 18.
This is of a different character.
Yeah, Julie, at this point, the decision's not final. So I'm not
Oh.
sure if this is the place.
Um,
These are going to the chief. The
Okay, all
finding.
right. Okay. Well, at whatever, but doesn't the complainant doesn't get this yet?
The complainant gets something, but they're gonna get something later too.
Well, I guess I don't see the downside, because I've been in several of these where we feel kind of bad for the person because they need help, and maybe actually they've been helpful pointing us towards some policy that needs attention, but there's been no place to tell them that.
Well, that's what
so-
this section does.
That's what, no, but this is follow-up and it's optional. So it's not something they get in writing unless they feel like chatting.
Which
Well,
part's
I
part's
guess
optional?
I don't understand why we can't
B is
send them something
Roman
in
numeral 5 is
writing
optional.
later.
Why can't it be after the chief makes,
Right, why can't it
Final
be after the
decision.
decision is final?
yeah,
Yeah, I guess that would be okay too.
because that's wrapping up the entire complaint. So at the end of wrapping up the complaint, you got your final decision, and here's, some resources we can direct you to. Here's, a survey, blah, blah, blah.
Yeah, I mean, another option would be to say, the decision is not yet final because it's going to the chief, but in the interim, we will notify you when the decision is final. In the interim, you may wish to consult with these resources or something. I'm just feeling bad for some of these people where their specific complaint doesn't have merit, but they could use some help. And I just see them maybe feeling bad if they just get a very cold kind of, a rejection without anything. And I didn't see the harm in adding something, but I understand it isn't final.
So
Is there-
so help me understand when you say, here's some resources, give me some examples. What do you mean?
Trying to think how this has come up, because I know it's come up several times.
Mental
Katie,
health.
can you- Yeah,
Mental health resources, or remember the case of the, well, I don't know, let's say somebody has their car towed and
right.
we give them the information on who to contact if an appeal might be appropriate, or I don't know, just,
And we also looked at the towing policy as a result of that case.
right. And so the
So-
resources would be specific to the particular case, but sometimes,
Correct.
and maybe it won't be relevant, but sometimes it could be relevant.
Right, and we only do it if it's relevant,
Yeah.
but.
So this would come directly after our hearing, but before the title is hearing follow-ups. So when
Right,
we
no.
say
And again, I don't think
No.
there's any harm in having it both places, but this isn't in writing. I mean, this is optional, so they might not even get to that point. They might feel so discouraged that they're like, I don't want to do your survey, So
So
What do
What
you
are
think?
what do you guys think? Lieutenant Montgomery, is there, or Kathy? And
I want to know what we're asking the subject officers.
We're not asking the subject officers anything.
Well, here they are.
An exit interview.
Oh, I'm sorry. I thought you were talking about my suggestion.
No,
I guess
I'm
asking
sorry.
them what they felt about it. Did they think it was fair or right?
How satisfied they were with it. I don't know,
Right.
just
getting their feedback.
yeah, I guess it allows them an opportunity for input into the process.
Right.
It feels like justice sort of implies maybe dissatisfaction at times, and it's hard to be responsive to that or super responsive to that. I think something written that covers it all would be the best case scenario, as opposed to somebody's upset because they didn't prevail. I would think that you were trying to deliver justice in that case. Seems like a one size fits all. If you have concerns, talk to the DPA or something like that. They can walk you through because they've already got a relationship with their investigator, maybe through the process.
Sure. So is there a form, time check too, is 8:53. Is there some kind of sheet that you send out with resources of that sort?
Who are you asking?
No,
Director Lee and investigator?
no.
No, okay. And
Although
everything,
we have, a while ago, I think Byron and I talked about following up with complainants. We've never thought about following up with anybody else.
No, I did. But I'm just going back to what Lieutenant Montgomery said about doing it in direct connection with any results from this in this particular investigation. I think we should consider surveys and the like. My issue is just when is the most appropriate time, because people are pretty ripe at times following a complaint hearing or complaint investigation, depending on how the results went.
you want to wait?
Yeah, you might want to wait a little bit,
Yeah,
which makes
I
the
think so.
resources, not as helpful if we're waiting, but
But if the answer is predictable, you're not satisfied because you weren't satisfied.
yeah, and we get that a lot, because they didn't get what they wanted. So, but I would want to.
This is really interesting because it goes so counter to a huge industry in procedural justice that says that if people feel they got a fair treatment, it doesn't matter if they get their way. And I've always argued, yes, it does.
Yes, it does. I've heard it. Trust me.
Let me ask
That's a
this
compelling argument, but I just think you'd evaluate the information.
Yeah.
So let me ask this question, and this kind of goes back to where this sits here. If the survey was done after the hearing, so the decision has not been made, depending on what's in the survey, you can ask the question then, because at that point, they don't know what the results are. They don't know whether they're mad or not. They don't know, so that emotional, I'm mad because I didn't get what I want. But you really get, okay, I really felt like I was listened to, I wasn't listened to, whatever it is that you want to ask on the survey, they're not colored by the results of the hearing. Maybe it does come directly after. Now, the resources, I'm not sure about that part, but the survey, maybe it's best right after the hearing.
Now, keep in mind, there may not be a hearing.
Right.
Because the hearings are optional.
Well, but this is saying hearing follow-up. So I'm just talking about when we have a hearing. So after a hearing, this is the follow-up after a hearing.
Yeah, but this is going to have to be changed, I think.
Well,
because
did
this was
board
assuming.
member Calavita intend this to be only for
No,
complainants who go through?
Maybe it should be entitled complaint follow-ups.
Mm-hmm.
Because you all are right. no longer necessarily a hearing. We can't do an interview or an exit survey after the hearing and before the disposition, because it's just, we do it all at once.
Let's just do it when the case is done.
Right.
Yeah. I
This
think
is right.
Complaint
And if they
follow-up.
don't want to do it, that's fine. I mean, it's
But if
not.
somebody files a frivolous complaint, and we're gonna ask them, how did you feel about that? I don't know. I
No.
personally
No.
like that.
If it's a frivolous
No, we're not
complaint,
gonna ask them.
if it's a frivolous complaint, it won't go through the entire process. We're talking about complaints that go through the complaint process.
Okay, well, we should make that clear.
Complaint procedure follow-ups,
I guess I preferred it just after hearing. Why aren't we doing it after hearings?
because sometimes there is no
There
hearing.
may not be a hearing.
But then maybe we don't care as much, right? I mean, I thought we were most concerned when there is a hearing.
Well, I think we care about all of them, don't we?
we hear.
Well, I think we could design a survey that's comprehensive enough, if your case went to hearing, ask them questions. If not, I mean, I think it could
Yeah.
be, yeah. We could address all situations, but I think it should come after their case is done.
Right.
And we send out a survey that you all will look at. That's long enough, not too long, to answer all the different scenarios. But I think a survey is a good idea.
Yeah, but if it's after the case is done and you're saying the final decision's been made, then you're gonna get results based on how they feel about the decision, not really how they feel about the process.
Well, that's all right.
I understand your point, but I think we'll take that I think that could be taken into account
Mhm.
if you asked them in the survey, were you happy with your decision? Then we could, that will tell us how seriously we take that survey.
Really, I was joking before, but there is enormous amount of research about court cases and all kinds of dispositions. And people seem to feel okay about it if they feel like it was a fair treatment. So we'll see. I mean, it'll be interesting to see.
The only thing about just doing a survey, I like a generic survey, but that doesn't really address, informing the complainant, like in the car towing case, that we, are going to look at that policy. So it needs to be a little more individualized, I think, for it to be very effective.
Yes.
But that was a particular case. I mean, where you could still ask the staff to do specific things in specific cases without putting it here in the regulations.
Right.
Well, yeah, I mean, the point about having something in regulation, it's just nice. It's like, oh yeah, it doesn't say you have to, you may. So it's just kind of acknowledging that that's out there. Anyway, I think we've
Why don't
done
we just
enough.
move? Okay, yeah.
Okay.
We don't have to, you're right, we don't have to have it in the regs.
That's true.
I mean, it could just be the practice.
I think with practice, though, you get, different staff and they don't know necessarily what the practice was. I think it's good to have things written down personally.
If we were
it's
to
important.
put it in here, what other modifications would you want in terms of what we just discussed?
I would say we need to reword this.
Okay.
Subject.
And maybe just call it follow-ups.
I deleted the S. Could we just say complaint follow-up? Because it is a follow-up to complaint, right? We're not going to ask them how they felt about.
Yeah.
Okay. That's fine. And then that alleged police misconduct hearing, are you suggesting to change that or delete it?
Yeah, change it to,
You want to just bring something back, Kathy?
yeah.
Yeah.
Yeah, let's deal with this.
We'll bring you
next
something
time.
back.
Good. So next time we'll start at the beginning.
Okay.
Right.
Yay, yes.
The
Sounds good.
beginning of anonymous complaints or the beginning?
No.
Just kidding, just kidding.
No.
So we were at 9:01. So we hit about 2 hours and 15 minutes. Not too bad.
So can I ask one thing? So now that we've gotten to the end of this document, I know we're gonna start back over, but can we have a clean copy of it to go back over? Because it's really difficult to read it with all of the.
Okay.
So now we're saying this is our first really good rough draft. And now we go back and play around with it again without all of it's really difficult to read it with all of that. So if we can have that.
Okay, so the only issue is there are some things from the beginning that weren't discussed yet. Because
Okay.
we would go through the sections and then somebody would think of something in an earlier section that we already talked about. And we said, well, we're gonna go have one last.
So can you leave just those things that we said we were going to go back to?
Well, the beginning of this document is pretty clean, I think.
I think so too, but.
So, and then,
I had a couple of things early on, but anyway. It would be nice to have a
cleaner copy to look at.
Yeah.
Would it be would it take you a long time, Director Lee, to go through and accept the things that we just went through, but then
no, that takes
leave
a
in?
little time. I'm just concerned that you don't talk about the things that weren't already. So this is something new from Kitty.
Okay.
No, Kit, I'm sorry.
Could we?
So
could we put
really
it-
can't.
Should we put it in another document or just put it all to the side?
The thing is, it's really hard to see what's new when there's so much old stuff, commentary.
Yeah,
and-
but I've eliminated everything that you've already talked about and agreed to.
Why don't we just put it in a separate document?
Put what in a separate document?
Those things that we still need to look at, the new things.
Oh, that's too much
Oh,
work.
that's too much work, I understand. And I can vouch for my director. She says it's too much work.
Thank you.
I'm just trying to find a way for it to be easy to just go through it, read it, and make changes on the new document, because for me, I find it hard to read with all of the changes in there. And I do understand wanting to make sure that we really scrub through the things that were added as we went through this. But I honestly get distracted.
Kathy's saying that everything that's now in there as comments are new.
There are some change. I wanted you to see what was changed in your November 30th, the last meeting before this. So I'll accept all these because some of this will go away.
Okay.
Right here, because this is what you talked about last time. I think this will be clean. That's a question I have to figure out. I think, yeah, this will be all accepted. And then this you agreed to tonight. I don't think there were any issues here. I think you agreed to all these changes, so I can clean that up. And then this is just going to be a mess right here. I don't know what to do because I can't. Cheryl, I understand what you're saying. I just think that it's not in that bad shape.
If I understand where board member Owens is coming from. If it makes it too complicated for you, then we're meeting next.
Can do, Cheryl, you can always create your own document. Or I could send out two versions. I could send out the one with the things you still need to look at, these suggested changes, and then I could accept everything. If that,
No, I mean, if you do one that has the things that we need to review still, that's fine. That's all I need. I mean,
okay.
yeah, if you do one with the things that we need to focus on, but the
All right.
things that we've already agreed on that's lined out and all that stuff, if you can get rid of that.
Yeah, I will.
Yeah, that's all I'm asking.
Oh, okay,
Okay, that's fine. Cool. Thanks for doing that.
sure.
Okay.
Okay,
So
Next
So the
week, is
next-
that when we're meeting?
pardon me,
When are we meeting again?
in a week, February
Okay,
3rd.
So that's agenda item 6, Chair, schedule or confirm next meeting, February 3rd at 6:45.
Thank you. Everyone is confirmed with that, February 3rd?
Yeah.
6:45. Okay, good. And I don't have the agenda in front of me to thank you.
The next item is public comment.
Yes, do we have any member of the public who would like to make a comment?
There are no members of the public present.
Okay, thank you.
And next is adjournment.
The one person fell off after listening for so
Well, we
long.
had a few actually at one point.
I make a motion that we adjourn.
Seconded.
Thank you. Second, adjourned.
Thank you.
Thanks.
Thank
All
you.
right.
Thank you.
Thank you, everybody.
Thanks a
Good
lot.
night, everybody.
Good night.
Thanks.
Have a good night.